Good morning, council members.
Morning.
My name is Ann Hars. I'm an artist, and I put balloons on rent-stabilized homes slated for demolition so that developers can build luxury developments in their place. I am very, very busy, especially in Valley Village. This election day, you want to build $1.2 billion worth of housing for the homeless, yet your policies of not holding developers accountable by using the tools you already have, MNDs, CEQA, are creating homelessness every day. I think the appeals process needs to be looked at very carefully. I think this appeals process for this particular development was not handled well, and I think that it would be a vote for affordable housing in this city if you looked at this case and very, very carefully. I appreciate your time on this matter. Thank you.
Great. Thank you very much.
Hi, Mark Simon, the Los Angeles Tenants Union. I just want to say once again that this is an opportunity for the City Council to use the law to support keeping from reducing the number of affordable housing units. Building our way out of it is only half the battle. Another significant part is preserving affordable housing, and we're going to be losing, in this instance alone, houses that were renting apartments that rented for $440 or $575. These are going to be turned into luxury condos, small homes that will be selling for $800,000. We can't just build our way out of this. We have got to preserve the affordable housing that's there. That is a significant part of this battle to keep the city in some sort of livable state. Thanks.
Hey, thank you. Good morning.
Good morning, members of the City Council. My name is Elisa Pastor. I'm an attorney with Glazer Weil, and I'm here today representing the applicant UV Valley Village. I urge you to please deny the appeal and uphold the approval of this vesting tentative tract map. That's what we're here about today. This was approved by the advisory agency in 2 hearings in the APC. The appeal was denied, and the appeal was denied at Plum. I can assure you that my client is either the owner of the property involved in this or has a purchase agreement to buy the 2 other parcels. We've submitted to council from the owners of the property affirmations that they did agree to allow our client to submit the application. It's on the land use form, and then we also submitted 2 affidavits very recently where they reaffirm that. We're happy to answer any questions here, and I appreciate your support.
Great. Thank you.
Hello, my name is Stephen Bowers, and I'm the last remaining tenant on a RSO property. I'm following up on Sylvia Shane's fair argument of significant impact. The housing element and even the city's CEQA guidelines emphasize as a policy imperative that the need to preserve and or replace existable affordable housing options. One way to achieve this goal with this project is to require the following mitigation measures as conditions of approval. 1, compel the project applicant to set aside units available for purchase by low-income individuals to compensate for the loss of 9 RSO units. This could be made possible through HUD-subsidized lending programs made available to qualifying individuals if the units are made available for purchase at reduced prices, closer to $300,000. Number 2, compensate the displaced tenants at amounts that exceed statutory requirements that are commensurate with the difference between the exceptionally below market rents that were in effect at the time and current market rates for comparable units. Thank you very much.
Mickey Jackson with the Coalition to Preserve LA. This is an advertisement for the Neighborhood Integrity Initiative that will be on the March ballot. You are inserting yourselves improperly into an unresolved legal matter. You are jumping the gun. You are going too fast. You are greasing the skids of this project before many very key legal issues, such as ownership, have been decided. People who are paid by people come here and they assure you and they tell you things, and this would not be the first time they told you something that wasn't accurate. George Abrams outlined these problems very well. You are putting yourself and you are putting the city and you are putting me and all the other taxpayers in harm's way by inserting yourself improperly into a legal matter. The title is clouded. You need to slow down, take a longer look, and really be careful.
Okay, thank you very much. All right, colleagues, that concludes all the speaker cards. Mr. Krikorian.
Thank you very much, Mr. President. I'd like the city attorney to come to the table, please. And I'd like to ask, Mr. President, that Mr. Herman be asked not to disturb the meeting, please, as we're trying to debate this issue.
Yes, Mr. Herman, if you wave your arms again or make animal noises, that'll be your last warning. We're going to ask you to step out. And if you brought any props, you need to keep them down and not wave them around because it's disturbing the people in the back.
Thank you, Mr. President.
Thank you.
I'd like to start first with the issues that were raised by the public relating to the impact on current tenants of the existing RSO building on this lot. And I'd like to ask, first of all, what the status of that has been, what the status of the tenants in that current building is, and what the impact of the Ellis Act has on their status.
Adrienne Porasani, City Attorney's Office. We wouldn't be able to speak to the current status of the tenants. We do know how the application was filed and that it was with the authorization of the owners to file for the map. We can speak to the potential impacts that were discussed, and I'll let my colleague Kathy Phelan explain the CEQA impacts.
Sure, and specifically as you're responding to that, there were a couple of references to the fact that with the application of the Ellis Act, that if there were a new apartment building built instead of what the applicants are proposing, what would be the RSO impact of that?
Well, first, as to the arguments related to the Ellis Act, and the matter before you is a track map and the CEQA finding. So if you have to comply with the Ellis Act, you have to comply with the Ellis Act. It wouldn't affect the track map findings, and that wouldn't inform your track map findings either. As to the CEQA, the Ellis Act on its own doesn't inform the CEQA analysis. CEQA analysis is whether or not you have a physical impact to the property. If there's a loss of affordable housing, loss of affordable housing on its own is a social economic impact. That's not a CEQA impact. It is only a CEQA impact if it will result in a physical impact. So if someone provides evidence that that loss of affordable housing will displace so many low-income tenants that new housing will have to be built somewhere else, that would be the CEQA impact. And staff is recommending that they have not found that evidence for the CEQA analysis.
Okay. So if there were violation of the Ellis Act by the owner of this property, there would be remedies that would be available, presumably, but what you're advising us is that those remedies don't impact what is on the agenda to be voted upon today.
That's correct. What's on the agenda today is the map, the appeal of the map, and the CEQA supporting the decision on the map.
And conversely, if whatever the action of the council is today on the track map, that will not impact on the availability of the remedies that the tenants would have under the Ellis Act.
Correct. That does
so
not
either
preclude
way,
the application
they're
of the law.
Unrelated issues. Okay. Now, the appellants discussed in their papers, as well as to an extent today, whether the proposal is consistent with the general plan, the community and specific plan, and as one speaker said, whether it fits into the neighborhood. Can you talk about those issues as they relate to the tract map approval?
So for purpose of the tract map, conformity to a plan relates to cutting up those lots in the size and allowing the density that will be allowed. The fact that this property is zoned for this density really speaks to whether or not it's consistent. If there's a concern about design or something like that, that's not a track map issue. It's really about, are you cutting up those lots consistent with the allowed density in the plan? And staff has recommended that, yes, it is consistent because the zoning allows this density.
Okay, so regardless of aesthetics or anything else, the issue is on the density. It is consistent with the community plan, with the general plan, and the Valley Village specific plan.
Correct.
Okay. Now, there were a number of issues raised with regard to the title, and as I understand it, that is currently actually subject to litigation. And I'd like to ask how that impacts, how the pendency of that litigation impacts on our ability to adopt findings or to make to take a vote on the tract map application.
So the council is acting on the application as processed by planning pursuant to their confirmation of the ownership based on the documents they received, and I think they also confirmed that with the county recorder's office. If a court finds that there was an issue with the ownership, then permits wouldn't be able to be pulled. I mean, that would be something that would affect the development of the project. But for your purposes today, and planning is here to explain their process as well, but for purposes of this appeal, it is looking at the decision and the recommendation that was made on the map by the planning department.
Actually, I think I would like to address that to planning as well, please. So again, the issue that I was raising was the pendency of the current litigation regarding title on the property. How does that impact the entitlement process that your department has to go through? And can you tell us, specifically the current title holder, what the position of the current title holder is and how that impacts on your decision making?
Council members, my name is Kevin Jones. I'm a senior city planner in the planning department in the Valley Project Planning section. Mark Wershing and I worked together with this project. To answer your questions, what we base our information on is the master land use permit application, which was filed in 2015. The document requires information about ownership, and what we do is that we look at the current owners, or we establish ownership based upon the zoning information and map access system, which refers to information that is supplied by the county recorder's office. What was supplied at that time and what is currently listed are two owners for the property that is to the north of Weddington. What that document also has on there are recorded grantees for other parcels, the two other parcels that were purchased by the Valley Village Trust, and that's an LLC. Our documents indicate that there is a document, an owner's and beneficiary statement signed by the owners of the two northern properties. One is a Marta Lathrop, and the other one is by a Sidney Edwards. It is they are both notarized documents done on different days, but the information that is contained in here, it indicates that that they agree that UB Valley Village LLC, the owner in escrow, is permitted and allowed to file for a small lot subdivision for the aforementioned property, their property as described in the legal description. Furthermore, the UB Valley Village LLC is responsible for all city fees related to the filing of the subdivision case for the project. So this is the information that was considered. It was found to be adequate for continuing the process of the subdivision case to create the small lot subdivision and the single family homes.
And so if something did proceed, if they are currently in litigation, a court would likely explain to us what the remedy is. And as I mentioned earlier, they wouldn't be able to develop the project going forward if a court found that there was an inherent problem in the title. At this point, the city hasn't been enjoined from actually taking an action on what's before us today, which is completing the decision on the appeal.
So if the current title holder seller and the potential purchaser of the property are pursuing the application, and let's say we move forward today and approve that and deny the appeal, at some point, before any construction were to begin, there would have to be an additional application process for that, and at any point, a court could enjoin that process if a third party who claimed entitlement to that property, claimed a right in that property, a court could enjoin anything from going forward.
That's right.
Now, what if it went the other way and we said, well, there may be a cloud on the title, some third party is claiming that they may or may not have an interest or a first right of refusal or something in this property, so we're going to deny the application until that's resolved. What would be the impact of that?
So again, our analysis would have to be looking at the facts. Are we going to be facing an issue with taking? What evidence do we have? I think that we'd have to do that analysis to ensure that we weren't violating the rights of the actual applicants in trying to develop the property.
So it would, the city could potentially face liability and exposure to a lawsuit by the current title holder and or the current purchaser of that property for our interference with their property rights if we were to do that.
Yeah, that's possible.
Okay. I have no further questions, Mr. President.
Great. Thank you very much, Mr. Harris-Dawson.
Stay.
Okay, you're done. Okay. So with that, colleagues, I don't see any other council members on the queue, so we can go ahead and open the roll, close the roll, and tabulate the vote.
12 ayes.
It's approved. Thank you very much.